Okay. All right. We might make a start. So welcome, everybody. Welcome to Kate and Phil, who are our presenters today. For those who were here last month, you're not imagining things. Phil is back. We had a fantastic session last month on cybersecurity. And we, but a whole other aspect of my business has to do with services for employers and helping them to get our crazy employment laws correct. So that is what we're looking at today, is how to be compliant as an employer, and for us who advise our clients, what do we need to know and what do we need to cover. So looking forward to hearing from Phil and Kate. So Phil, over to you.
Okay, thank you. I'm just going to share my screen. If everyone can let me know that they can see my screen, that would be amazing.
Yep, we got it.
Excellent.
And sorry, I will just interrupt. For those who haven't been before, please put your questions in the Q&A box, and we will we'll get to them if we can through the presentation. And if we haven't done that, there'll be time at the end for questions as well. So we can do both throughout the presentation and at the end.
Excellent. Thank you. Thanks for having me again. I'd like to thank you all for joining us today. And I know the time, it's around lunchtime, so everyone's nice and hungry and probably working off their computer or the phone at the moment. So I just wanted to introduce, for those that didn't join us last time, a quick intro on myBusiness. myBusiness is formerly Business Australia, and it's part of the previously New South Wales Business Chamber, now Business New South Wales. It's an online platform that backs small business. So myBusiness helps support owners to bring powerful management tools and big business tools to small businesses, basically. So we focus mainly around cybersecurity and workplace relations and IR tools. And part of that is our law firm, basically, that we all work together, and that's Australian Business Consulting, Australian Business Lawyers and Advisors. We have so many different names, it's so easy to get, and they all sound like each other, and Kate is nodding her head and she knows exactly what I'm talking about. So starting our session today with a quote from Richard Branson: "Red tape will often get in your way. It's one of the reasons I often carry scissors." And as we know, Australian workplace laws are some of the most complex in the world. Your best intention is not necessarily your best defense. A lot of us got into business or to help businesses to do something we love, leave a legacy, or for our family, or work somewhere we believe in, really. So when it comes to staying compliant and being confident that we are doing the right things, or we're doing the right thing by recommending things to our clients, often we get it wrong. And it's because it's so difficult to get it right, unfortunately, when it comes to compliance in workplace relations. And unfortunately, again, it will only take, your own stuff or your client stuff, $65 to put a complaint into Fair Work. And when that happens, you have to actually, of course, your clients have to actually figure out how to travel around that and what to do. And that always gets really, really difficult. And that's why in today's session, we're going to go through the core, the minimum you and your clients will need in an Australian workplace to keep you, your business, and of course, your people protected. We're going to go through 5 policies, and Kate's going to get into this in more details in a second. We'll go through 5 policies your business really needs, how to identify any employment policy or procedure gaps you may have, and of course, how to clarify any areas of risk in the workplace. Again, we know you work with a lot of clients, and these are issues that probably come up all the time. So we try to loop this into the basics, basically, but it's the really important stuff. So to get started today, I wanted to introduce Kate Thomson, Senior Associate, Australian Business Lawyers and Advisors. We call ourselves ABLA, basically for short, because we have so many acronyms. So welcome, Kate, and over to you.
Thank you. I'm going to share my screen now, so we'll have a battle of the sharing. Hopefully that works. Lovely. All right. Thank you everyone for coming along today. As Phil said, I know you've probably got lots of other things you need to be doing or worrying about, including lunch being one of them, but it's really nice to have you here and I'm really grateful for the opportunity to join you all. If you do have questions, please do interrupt. It gets very boring, me talking at you for any length of time, let's be honest. And I'm not particularly good at multitasking, so I do occasionally miss the chat box. So hopefully we can someone else can interrupt me and draw my attention to that as I go through. As you can see from the photo behind me, I'm actually based in our Newcastle office, but we have an office in Newcastle, Sydney, Brisbane and Melbourne now as well. So we're well placed around the Eastern Seaboard to assist you and any of your clients if you have any employment or corporate and commercial related legal needs. That's my little plug. Of course, everything I say today is just general in nature. If you need specific advice or if your clients need specific advice, please do reach out and obtain that from us. So today in our session, I'm going to be talking about four main things. As Phil said, what are we talking about when we talk about compliance? What do we need to have in place in terms of written documents to ensure compliance? Where the gaps are, how do we work out where the gaps are? Because sometimes we don't know what we don't know. As I'm sure you guys are all aware, that can be one of the major issues when you're advising clients is ignorance. They don't know that there's a problem until it's too late or until they have someone like yourselves draw that to their attention. And then finally, just a couple of tips and tricks for rectifying areas of risk. So this is a really good segue into this first slide here, which is what do we actually mean when we're talking about compliance? And I think the first one is really just knowing sources of legal obligation. So hopefully, when you're working with your clients, you're talking about modern awards, you're talking about the Fair Work regulations in terms of pay slips and all of those legal requirements as well. But there's heaps of them. And this is, as Phil said from the outset, people say, oh, I don't understand why people are non-compliant with their workplace obligations. It's pretty simple. We often have discussions in our office about the fact that that's just not true. It isn't simple. It's really complex. There's lots of sources of legal obligation, and it's really easy to find yourselves or for your clients to find themselves in hot water really quickly and unintentionally. So we need to know what we need to know and be aware of and conscious of and be compliant with. We then need to be aware of the fact that we either are complying or we're not complying. We need to protect our legal interests. So I'll stop here for just a second because I think you guys find yourselves in the really unenviable position sometimes of telling people what they should be doing, but then also assisting them in terms of their legal compliance stuff. So if you're processing payroll, for example, you might have said, look, you need to be looking at your rates of pay in respect of this award. They've gone up. Or, based on the roster or the timesheet I've received, I don't think that's the correct penalty rate that you've instructed me to apply that at, depending on, of course, how much control you have over that end of the process. But, and as I'm sure you're all aware, because of your involvement in that process, you can be in the gun as well in terms of legal responsibility. So we're not just talking about the advice you give to your clients, which, as a first port of call is really important. And I'm sure is one of their most trusted sources of that guidance and advice. We're also talking about the stuff that you need to worry about from a professional perspective too. Documentary framework is the last point on that slide. I think it's really, really important because, I talk a lot about, you need to know what is out there, what you need to be compliant with, but the back end of that is actually just having support systems within the workplace which enable you to do that. And then also, if something goes wrong, have you got the records to substantiate what you were doing so that you can dislodge any assumption about, the manner in which you were paying people or the manner in which the client was rostering people. So do we have the records and the documents to support us? So at a high level, we've got four, I think, main sources of legal obligation that we need to be concerned with. So Fair Work Act, of course, is right up there. Depending on where you work and the industry in which you're working and the people with whom you provide services to, you might have state-based legislation which is relevant there as well. We can't forget about that. the national employment standards are part of the Fair Work Act, in a number of important ways. One of them would be, leave entitlements and those basic sets of terms and conditions that all employees get, regardless of how well remunerated they are or the industry that they're in. Work health safety legislation is really important there as well. Might not be necessarily something that you're dealing with your clients on a day-to-day basis, but it's certainly something if you have your own employees that I'd encourage you to be conscious of and aware. And then, other things like discrimination legislation as well. So we get very caught up on worrying about pay, and I'll talk about that in a moment. And we forget sometimes about all of this other stuff that we equally need to be concerned with. So then we've kind of got that as our, our fundamental level. Then we build upon that with our modern awards and potentially also enterprise agreements. So I don't want to tell you guys stuff that you already know, but obviously there's about 130 plus modern awards covering a range of industries and occupations. They set, our things like our rates of pay, our minimum terms and conditions from an industry or occupation specific perspective. Some people, and potentially even more people in the next 12 months or so, if the industrial relations reform become law, and you might have seen some of that in the media, we have some clients who might have enterprise agreements that they're applying as well, or might be exploring that as an option. So that's taking, the modern award, which is intended to cover all sorts of businesses in an industry or all sorts of employees, and making it more specific and bespoke for a particular business. And again, depending on what happens in the next couple of weeks, we might have that on an industry-wide basis as well. So interesting thing to keep an eye on there. So then we go even more specific. So we've kind of started at the global level. We've gone to the industry or enterprise specific level, and then we talk about our individual employees and what's written in their written contracts of employment. But equally, we have to worry about implied contractual rights as well. So I talk a lot, and I'm very enthusiastic about the value in having written employment contracts. And if there's one thing I think you could advise your clients about, it's that you need to have written employment contracts in place as a risk management strategy. That's great. But then I go and add in this extra level of complication, which is to say it's not just about what's written in the actual contract of employment. We have to worry about all of this other stuff as well. So I won't talk too much about that today, but just to be conscious of the fact that, we talk about duties such as, fiduciary duties and duties of goodwill and good faith, those sorts of things. That's what we're talking about when we're talking about our implied contractual rights. And finally, and I do talk a little bit about policies and procedures here because I think, in the course of giving people advice in the work that you do, I said already, employment contracts, part of that recommendation that I'd be advising you all to give to your clients. The second part of that is having some policies and procedures in place. These are the two main ways that we see people being able to manage their compliance and manage their risk appropriately. And without them, it's always going to be an uphill battle, either to achieve positive change within a workplace, having a clearly articulated set of behaviours and performance standards that people need to be complying with, but then also, from a purely compliance risk perspective, do we have a policy which says you need to take your meal breaks? Do we have a bullying and harassment policy which will assist us if we end up with some kind of claim? Those are the key reasons, we talk so much about these documents and the central importance that they have when we're talking about compliance. So I mentioned briefly just a moment ago, we do get very caught up on thinking about monetary stuff when it comes to compliance. And I know that would be a lot of what you worry about and a lot of what you advise your clients about. And again, I'm not telling you how to suck eggs because I know this is something you'd be more than conscious of. But when we're talking about monetary considerations, we can't just worry about rates of pay, even though that's really important as a starting fundamental concept. We need to be thinking about penalty rates, allowances, overtime, and all of that kind of stuff as well. And when I'm talking to people about this stuff, I'd like to emphasize the fact that, just because a particular modern award or some modern awards have a method of calculating overtime or a method of applying penalty rates, depending on whether someone's a casual or whether someone's a permanent employee, we can't just apply that across the board because, as I said before, this is really confusing and complex. there's different ways of calculating these entitlements depending on the award. They couldn't do something straightforward like make it simple and have a consistent application. Of course, that would be all too hard. So that's, I think, rates of pay really important, but the second part of that is knowing what the award says in terms of how we're actually calculating that stuff. The second point there is, I've called it non-monetary considerations. It can sometimes have implications for monetary considerations in terms of, are people entitled to overtime pay for working particular hours? But this is the stuff we're really talking about when it comes to, those conditions of employment that are separate from just monetary things. But they're still as important when it comes to compliance. It might not mean that there's an underpayment bill sitting there for your client if they're non-compliant, but they could still be engaging in a contravention of the award, potentially also the Fair Work regulations, which could see them end up with fines and other penalties. So that's things like, are we rostering in accordance with the modern award? Are we compliant with hours of work, leave entitlements, all of that kind of stuff as well. So, I think that the dichotomy between monetary considerations and non-monetary is sometimes, oversimplified. Oversimplifies things. They're equally as important. It just, depends on how bad things can go, how quickly. I've put number 3 there, record keeping, because I'm sure this is something which is forefront of mind for you guys. Probably have ongoing disputes or arguments with some of your clients about the quality of the records that they keep. It's one of the reasons why you can be a real help to them in terms of how they're ensuring their compliance and being able to demonstrate their compliance as well. Super important. And I think, if I look at my clients and the advice and assistance we provide, record keeping would be the most obvious common error that people make. They might be entirely compliant with all the other stuff, but if you can't substantiate the fact that you have been compliant or you are compliant, you may as well not be, because there is a provision in the Fair Work Act which basically says if you don't have the records to prove it, then we don't really care. So it's this really unfair situation for employers and advisors to be in, which is reliant on the documents, the paper trail, in order to substantiate compliance.
Kate, I'll jump in there because, I think that's a really big factor in our world. And I know, I've talked to a number of people who've had disputes with clients about who was responsible, and the client, even if there's an engagement letter that says, the records are your legal obligation, they somehow manage to miss that and think that because we're processing payroll and we're keeping our work paper notes, for example, that therefore we've got everything they need. And so I know that that's not an uncommon issue, is record keeping and getting employers to understand the importance of it.
Oh, it's
sometimes a bit uphill. So,
Absolutely.
If anyone's got any comments on that, you're also welcome to make comments, guys, about, what we're talking about as well.
For sure.
It's, and people get caught out because, of course, we can come back and say, well, no, I don't have those records. That's your legal obligation. And then they don't have it.
Yeah, and they're going to be very cross with you unnecessarily.
That's right.
Because
Yeah.
you've complied with the terms of your engagement. I'll give you a quick example about how important that is because it's recent. So we have a client who was an accommodation provider, a small motel, and had a lady who did evenings, for quite a number of years. Unfortunately, that employer didn't keep sufficiently detailed records. There was no account of, exactly when she started and finished work on each day, how many hours she'd worked. He basically did payroll himself, kind of on the assumption that she'd worked the hours that they'd agreed that she'd worked, and that wasn't necessarily the case. She had been keeping a diary, as we all know employees are inclined to do. She made a complaint to the Fair Work Ombudsman about allegedly underpaid entitlements or paid entitlements that weren't paid to her. And the Fair Work Ombudsman came along and said, well, she's got the records of when she says that she worked. You don't have any records to convince us that that was anything other than what she's saying she did. So therefore, we're going to calculate the underpayment based on her diary entries. And we had really no capacity to say, well, no, on this occasion, I know that couldn't have been when you worked because I worked, for example, which was the case in a number of instances for that employer. He was able to say, well, that's just not right. I know that that period of time I was on holidays or whatever, and this would have been the case. We just didn't have the records. So they ended up with an underpayment bill that probably they shouldn't needed to have paid if he'd had the appropriate documentary basis to support.
Yeah, that's a good example. I don't know if you're going to cover this later on, so you can stop me if you are covering this, but that makes me think of, what in our role, where do we stand if we've advised the clients, you need to keep time records, you need to keep, your timesheets, your agreements, et cetera, et cetera, et cetera, and they don't follow our advice. Where do we stand in that? Because a lot of us have clients who might be in the grey zone. We know they're absolutely fine. There's nothing, we don't want to get rid of them. But yeah, maybe we know they're not keeping their records correctly. And we've advised them and they say, don't care, What is the practical advice for us? Because we don't want to lose a client and income because we've done our bit of advising them, but then we know that they're not following it. What's your take on that?
Yeah, that's a question I do some work with an accounting firm, sort of in a similar vein to the work I'm doing with you guys today. What we decided on there was basically, there would be confirmation of the advice in writing, preferably more than once. And then if it came to a point where the practitioner was so concerned that there was non-compliance with the advice, they would cease the engagement. And that was a business decision that they've made in that particular firm, and that's available to them. And it might be different to someone, for example, who's listening today, who might only have a handful of clients, and that's the scale of your business, and you're cool with that. But the reality is, because of the accessorial liability provisions under the Fair Work Act, you do have liability potentially, particularly if you know that person's not following your advice and you're continuing to facilitate. More so, I would say, in terms of if you've given advice about a rate of pay or a particular entitlement, and you know that that person's not following your advice because they're asking you to process the pays in a particular way, that's a massive red flag. And I think that would have to be one of the circumstances you would say, no, sorry.
My understanding is that accessorial liability does relate particularly to underpayment. It's not so much about the non-monetary considerations that you've got there. So, if we've advised them and they're not keeping those records, that's not so likely to involve us in an accessorial liability role.
Not as likely. Still potential, because you can be involved in the contravention, depending on the nature of the contravention. I would say, though, it would, the way I kind of always assess the risk when it comes to contraventions is to say, well, we start at the top, which is the underpayments or the non-payment of entitlements. That's the area that you're most likely to get into trouble for and about. And then we kind of work our way down. So if we're talking about record keeping, just being this sole contravention, I would say it's probably fairly unlikely that they, grab the person doing the payroll into that equation as well. But not necessarily impossible, and it would depend on the circumstances. So yeah.
Well, that's part of our problem, isn't it? That so much is, general principles, and they're just 10,000 variations that are possible, and we can't know them all
entirely. Yeah.
Anyway, Celia's just wanting to clarify with your story. Presumably that was when the employee left. Otherwise, wouldn't you expect that she would query her payslip when she received it? Or was that part of the problem, that she never got payslips?
She got payslips that reflected what they'd agreed on. So this is the issue. So she did basically, when she finished up, she was an older person. She retired. And she came back and said, oh, hang on a second, I think I've got all of this money that you owe me, and did not raise it during the employment. So
Yeah,
yeah,
that's a common story, isn't it?
yeah.
Unfortunately. Yeah. Anyway, I'll stop interrupting you now.
No, that's all right. Thank you. I appreciate it. So what have we got? What would we recommend to support compliance? As I said, employment contracts, super important. I'll talk about that in a moment. Enterprise agreements. I don't know. It's really uncertain about how to kind of look at these at the moment with the bill before the Parliament. I think if you've got clients in particular industries, you might be saying, hey, have you thought about this as an option? Because if you haven't thought about it, you might end up getting forced into it in any event. There can be good things about enterprise agreements. You know, if the modern award is inflexible for your client, it doesn't really support the way in which they work, that can be a good reason why you might think about an enterprise agreement. Policies and procedures, as I said before, super important, the second part of that equation with the employment contract. And then, of course, our third party documents. So the Fair Work Information Statement, the Casual Employment Information Statement, stuff like that. I will just mention, because I was just doing a presentation this morning about paid family and domestic violence leave, there will be another version of the Fair Work Information Statement coming out early next year once that becomes part of the National Employment Standards. So I don't know, you guys probably find this as well, but what I find with our clients is they'll download a version of a document at a point in time and continue using that version forevermore. So whether it's the modern awards, whether it's the Fair Work Information Statement, it's the version from 3 years ago. So just maybe a good opportunity if you're speaking with people in the new year. You know, did you know about this upcoming change? You know, you'll need to download new versions of your documents as well. As I said, employment contracts, super important. The argument that I have with people often is, we just engage casuals, so we don't need them. I don't worry about them. That makes me feel really uncomfortable, to be honest with you. I would say casual employees are almost more important in some ways to have employment contracts for. As you would all be well aware, there has been a lot of controversy in the last sort of 4 or 5 years about the nature of casual employment. So if your clients do operate with predominantly casual workforces, so if they're in hospitality or those sorts of industries, still super important to have employment contracts. So the nature of the engagement from the outset is very, very clear. And that's one of the main benefits of having an employment contract in place. It's, you're going to come and work for me. These are the agreed terms and conditions, and you're happy with that. That's what we're starting the bargain based on those agreed terms and conditions. If we subsequently have a dispute about what was the nature of the relationship, at least then we've got something to go back to and say, well, look, no, this was how we set up the relationship from the outset. So you can't really turn around and say you didn't understand, because I've got this document that was signed by you. Likewise, if you've got lots of part-time employees, super important, because as you would know, modern awards have different arrangements for the engagement of part-time employees, the level of detail you need to have when you engage them, and that can end up being a really costly exercise if that's wrong, because, for example, we might end up having to pay overtime for hours in excess of their agreed hours if we haven't set up that relationship properly. A lot of people operate on the understanding that you can just pay someone at ordinary rates up to 38 hours per week. That's not necessarily the case, and is one of those areas where the modern awards do differ quite significantly. So depending on the nature of your client's business, you know, will depend on the level of complexity that they need when we're thinking about all of these documents, frankly, but, you know, particularly contracts of employment. So Phil just took himself off mute. He's probably wanting to ask me something curly.
It's quite, no, I'm going to keep them simple, but one of the examples we see all the time in the workplace product is clients coming to us for the first time, and their contracts are from a download from Delaware in the US, and they're trying to use a US, something they downloaded off the internet. And we're looking at these contracts, and then obviously they talk to ABLA too, and we're like, no, these things were set up for a different country, first of all, but also missing a lot of important detail. And I've heard lots of stories. My lawyer, my accountant has given me these documents 8 years ago. It was good enough for me back then, so I'm keep using these. Or I worked for someone X amount of years ago, I'm using the same contract, should work for me, right? So I think one of the things that, as some more business owner myself in the past, and coming from a family of small business owners, we think, oh, it should be enough, right? And with the environment's always changing, and things are always changing at Fair Work with new, domestic and family violence leave, all these things coming out. It's so important to have updated contracts, updated engagement letters, and updated policies. You can't have something stopped in time and keep using it into the future. That's where I see a lot of our clients coming to us. In the product, we obviously have 6 or 7 different contracts of employment, from simple to comprehensive, and engagement letters that work a little bit like that. But how important is it keeping up to date with the contracts?
You're so right, Phil. And just as I was saying about modern awards and Fair Work information statement and stuff like that, people do take a bit of a set and forget approach to some of these documents. And a lot of it doesn't change fundamentally, but it does change. The casual employment example is a really good example of that. In the last couple of years, there's certainly been changes to the way we recommend people draft their casual employment contracts. Likewise, independent contractor agreements, those sorts of things as well. So yeah, you're right. If you've got a version, or your clients are using a version that they got, they might have purchased it 8 or 10 years ago, perhaps when the Fair Work Act was introduced in 2009, 2010. Look, it might be okay. It's probably better than nothing. But certainly we can't just say, well, it should be fine, and it's the best way of protecting our interests, because more than likely I'd suspect that that's not the case. Andrea's got a question. I just saw it pop up in the chat box. With contracts of employment and current employees, should the updated contracts be signed, and how often? Yes, absolutely. Always best to get people to sign documents if you possibly can. The way I like to do that, and suggest people do that, is if you're offering a remuneration increase, is often a really good time to actually have that discussion about the contract. Say, here's your new contract. It's got your updated hourly rate in it. Please sign. The fact that someone refuses to sign isn't necessarily fatal. If they continue to show up at work in accordance with the terms and conditions set out in the contract, we can say that they've kind of accepted by conduct. But generally speaking, if we can have them sign, that would be best. In terms of when to have new ones, like I said, you might want to think about it if you are giving someone a pay rise, a different role. If your fundamental foundational document is okay, you might just want to do a variation letter which sets that up. If you've got nothing in place at the moment, yeah, pay rise time is a good example. We don't need to change these things all the time as well. So if you've got someone who has a perfectly fine version from 3 or 4 years ago, there's no real reason, I suspect, why you can't continue using that, with the caveat that as long as it actually sets out what they're still doing. That would be my major thing, because quite often what we see is people who come along to us and say, I'm having trouble with this employee. This is their employment contract. I know it says this role, but that's not what they've done for the last 2 or 3 years. And we've got to try and reverse engineer what they're actually doing now, because it's not reflected in the document.
There's another question there for you, Kate. How do you know if something changes with Fair Work, even if it's a basic as a rate change? And I think, obviously following those modern awards, because they do move around a little bit every now and then. It's how do people, in your opinion, stay up to date?
Yeah, good question. It's tricky. I don't have an easy answer. I've got a couple of suggestions. One is you can sign up to award subscriber services with the Fair Work Commission. That can be a good way of doing that. You can sign up and keep an eye on the Fair Work Ombudsman pay guides. They do update them fairly regularly as well. There's a whole range of I really like the Fair Work Commission's resources, they really try and make it as easy as possible for employers to keep up to date. The Fair Work Ombudsman, of course, as well, has a really important role to play there. But just as a general principle, I don't like the Fair Work Ombudsman, so I'm loath to recommend their services. But that's not to say that they don't have some great resources available as well. So basically, it's just working out, what we need to be concerned with. So, for example, which modern awards, working out whether there's a subscriber service. I believe, and I'm not sure, Phil, you can correct me, we used to have the capacity to sign up and identify particular awards.
We still do.
We
still
do.
do.
Amazing. So yeah, if your clients are signed up to their awards with myBusiness, we will also keep you up to date with that as well. And that's not just, oh, this clause has changed. It's, this is the clause that's changed, and this is how you'll need to change your approach to calculating payroll or whatever it is as a result. So we kind of give you that. This is the change, and this is when you need to worry about it and how. So just before I move on from employment contracts, because I'm very conscious of the fact that I could talk about this stuff forever and not leave anyone time to talk about anything else, I will just point there to one of the recommended clauses I think is really important, particularly for your clients, and that's the compensation for all legal entitlements set-off clause. The reason this is really important is if you have clients who are paying people a salary or an all-up hourly rate that they are intending to compensate for additional monetary entitlements, you really need to have one of these clauses in employment contracts, which sets that out. So what I mean is, if you have someone that you don't necessarily pay loadings to, you don't necessarily pay allowances, all those sorts of things in the modern award, because we've set their salary at a level which is enough for their 38 hours per week and all of that additional stuff. That's all well and fine, but what we really need to have is one of these set-off clauses. The way the clause works is we say, you understand and appreciate that we're compensating you for all legal entitlements by way of your salary. If we underpay you, which we will if we're paying in that way, in certain weeks, we will offset with additional overs in that week as well. So it basically just gives us that capacity to say, yes, we are underpaying you because we're not paying you all of these specifically identifiable entitlements, but we're allowed to do that because we've agreed that, we're overpaying you with respect to some stuff, and you're acknowledging that that's all good. If you don't have one of those clauses and your employee or your client's employee comes and says, oh, well, yeah, I do get paid a salary, but I should have been getting paid overtime as well. And the client turns around and says, no, we compensated for that in your salary, you're going to have a hard time of it. So what ends up happening in those circumstances is the employee will get their overtime, for example, calculated on their salaried rate, which should have already compensated them for it as well. So yeah, really important one from a payment compliance perspective. So if you've got people you're thinking about now that you go, oh, I know that they pay like that, definitely compensation for all legal entitlements and set-off provisions. Pardon me. Policies, I'll just talk about relatively briefly because I think it's important for you guys to be conscious of and cognizant of the ones that you should be recommending to your clients. But, other than suggesting that they all sign up to myBusiness, you might not necessarily be getting that involved in the nitty-gritty of, helping them draft them. I think it's the case that, we need to be conscious of, what business are we talking about? What's the particular circumstances of that business, and what might their needs be in terms of their policy documents? It's really important, I think, just to, from a foundational perspective, set out those expectations. This is how you're going to do your work. This is how we expect you to turn up and do all of those things. It provides managers with really important guidelines. It can also just meet legal requirements. So one of the ones that I'd be encouraging everyone to have a bit of a look at, and I'll talk about this in a moment, is people's bullying and harassment policies, specifically sexual harassment. Again, something in the bill that's coming up, there will be increasing focus on sexual harassment. There already has been, but if you're having a general discussion with your clients about, these are the things that you need to think about in the next 12 months in terms of your compliance, definitely think about sexual harassment. Question, isn't it the case that a salary can only include a reasonable amount of overtime? Yes, but the what's reasonable will depend on the circumstances. So, for example, when I'm advising someone who wants to pay a salary, what I suggest is, okay, we'll work out how much overtime you think that person's going to work in a week, and then work back from that. So we really need to have an idea about how much overtime they might actually work, how many additional hours. So that's going to be relatively straightforward. If we've got someone who we need to work, a 45-hour week, for example, we know what they'd be entitled to if they would be paid for all of that overtime as a separately identifiable amount. We can do that calculation. Becomes a much more difficult proposition when we're not sure how much overtime someone's going to work. So we can really never be certain that we are compensating them for all of that overtime. So yeah, really important thing to be thinking about. If someone is proposing to set off overtime, you do need some level of clarity around how much overtime we're actually talking about. So if I have 5 that I recommend, and you could potentially recommend to your clients, what are we talking about? Code of conduct. So that's, just this is how I expect you to behave. Bullying and harassment, as I just spoke about, really important from a legal compliance perspective, as well as, of course, just making sure that people are doing the right thing and there's consequences that flow if they're not. Complaints and grievances. So how do we handle complaints about perhaps bullying and harassment, perhaps code of conduct issues? IT and social media. So Phil and Joe referred to before about, you've had a cybersecurity kind of vibe in the last presentation. Really important to be dealing with that stuff from an employee perspective as well, how people are representing their employers in the public domain, and then work health safety as well. So I appreciate that's something which probably, you might not necessarily be advising on the nitty gritty, but those are the ones that if your clients are coming to you saying, what do we need? These are the ones that, I would be recommending as well. If you have employees of your own, these are the sort of basic fundamental ones that I think are really important. If I had to pick one, it would be the code of conduct, though. It's just, our general overarching, this is what we need you to do. This is how we need you to interact with members of the public and your colleagues. It basically gives you that capacity to manage all sorts of types of behaviour within the business. Equally, bullying and harassment, as I've already touched on, really important for the other legal obligations that we're talking about too. So as I said before, we get really caught up on the Fair Work Act when we're talking about employment law compliance. It is the most significant single piece of legislation, but we do have all of these other stuff and other sources of obligation we need to worry about. Work health safety is really important. I can see there's a comment just in the chat under work health safety, the area of mental health. Oh, it's huge. What is the extent that employers should be involved in this area? I mean, how long is a piece of string, to be perfectly frank?
That's
This
another
is
webinar in
Oh,
itself, basically.
majorly. Yeah, totally. It's just one of the most significant areas of risk for businesses at this point in time. I can't put enough emphasis on it and its level of importance. If you are advising people who have workers' compensation claims, I would be willing to bet that a lot of those claims relate to psychological injuries. They are, increasing exponentially. So we've got a workers' comp minimisation risk as well as a discharging our work health safety obligation risk when it comes to mental health and psychological injuries. So what extent should employers be involved? To the extent they possibly can would be my recommendation. If you think you've gone far, you probably haven't gone far enough. But as Phil said, that's a whole other webinar that I'd be happy to come back and talk to you about some other day. Complaints and grievances, as I said, just basically telling people how they can complain about things and how those complaints will be dealt with if and when they're received. It's a really important closing of the loop. When we're talking about, the Fair Work Ombudsman and those sorts of regulatory authorities as well, the benefit of having a complaints and grievances policy within your workplace, within the client's workplace, is that hopefully they don't see the need to go to those external third-party people to complain, because they can see, well, if I've got a complaint, I can come to my employer, I know how they're going to deal with it, and we can try and resolve it at the workplace level without having that third party come into play. So the example that I gave before about our motel operator, that lady never gave the employer the opportunity to actually talk about or resolve any of those concerns. Maybe it would have been no different if there'd been a policy in place, but I think that's a really important way of hopefully getting people to try and resolve things at that workplace level before they go external. IT and social media. So two parts of that. IT is really talking about workplace surveillance. So another compliance thing that I could talk about for, an hour of its own, but I won't. And then social media as well. So I'll just briefly touch on those two. Work health safety, as we've sort of alluded to in the context of mental health, really important to basically, set out, these are the things that we're going to do. These are the ways we're going to try and manage our risks. Having regard to the particular circumstances in the workplace. So if your clients or you're talking to people about how to start doing some work in this area, there's a couple of ways I would suggest looking and starting that inquiry process. What are the most recent risks and issues that have presented themselves in the business? So, have we had a number of bullying complaints? Have we had a number of workers' compensation claims? Have we had a number of pay irregularities that we need to worry about? These are all the sorts of things that you go, oh, okay, that might be a prompt that we don't have a document, a procedure, a policy in place to enable us to respond to those things appropriately. Second part, and again, harping on about the same themes here, but just because we've got these documents in place doesn't mean we should set and forget them. So we might have a client who has perfectly fine policies or perfectly fine contracts of employment, but they haven't looked at them for 5 years. I'm willing to bet they no longer are suitable, or they're no longer as suitable for the needs of the business or the way that they work now as they were 5 years ago. Working from home is a really good example of that. Who would have thought 5 years ago you would have had large portions of your workforce working from home on any given day of the week? I know I certainly wouldn't have. Let's look at those things, look at those opportunities, and use them as a prompt to undertake a bit of a review. Awareness is another issue. So I can't count the number of times I've had a chat with someone, particularly, and even businesses who have great documentary frameworks. And you say, okay, well, where are the policies kept? How do people access them? Do they know where they are? Oh, they're on the internet, but they're really hard to find. Or they're in a printed folder in the lunchroom that no one actually goes into anymore because it's down the other end of the site and we don't really use that anymore. And there's no benefit to anyone in having policies and procedures and contracts or documents of any kind if people don't utilize them, if they're not aware of them. And also coming back to our focus on record keeping and being able to prove things, if your clients have great systems, processes, policies in place, but they don't have any way of substantiating the fact that employees were given a copy, they understood, they appreciate all of those sorts of things, ideally by signing or acknowledging online or however, then we're almost in the same situation as we would be if we didn't have those documents in place at all. So proving people know about them is really important. And this final one is a really cheerful way of looking at life, but it's how we look at life as lawyers, unfortunately. There's a lot could be said about that, but we won't go into it. Worst case scenario testing. So if you think about an issue, take our issue we were talking about before where you're advising someone who isn't taking your advice. Let's go worst case scenario with that. What could possibly happen as a result of that? And let's work back from that and try and put into place some protective mechanisms, some steps, so that if that worst case scenario does eventuate, what have I got there to rely upon? Likewise, if you've got clients who are talking about potentially needing to make some people redundant or termination of employment in other circumstances, what could happen? What's the worst case scenario that could happen? And let's work back from that and work out proactively what would be the best way of managing that risks. Question about usually work from home, injuring themselves at home during a post-COVID. I haven't heard any mention of this risk. Has something changed? No, is the answer to that? Absolutely not. The risk is still there. It's still really important. I think, to be honest, what's happened is that everyone just needed to work from home. So our usual ways and strategies that we would have suggested to people to manage those risks were kind of just put to the one side because, basically we were all given a couple of weeks to completely change our method and mode of working. If your clients or if you have employees who are working from home moving forward, I would really strongly suggest, now things have settled down a little bit, hopefully, and fingers crossed, this is the time that we would say, okay, we've stopped being entirely responsive to what's happening externally. Let's look at our audit. Do we know that people have appropriate chairs, appropriate screens, desks, test and tag for their electronic equipment? I'll mention this one as well because I'm on the theme from this morning. Do we know that people are actually safe working from home? Is there someone in their life who is potentially perpetrating violence or other, psychological coercive control stuff against them? And by putting them in their workplace at home, is that potentially becoming a workplace issue? So thank you for asking that. Yes, the answer is nothing has changed. It's just that circumstances have distracted us, basically. And I suspect the safety regulators will be coming to, coming back around to that one as an area of focus before too long. So little diagram here just to summarize some of the key areas of risk. Terry said teachers had to provide an OH assessment of their own home. Yep, exactly. And if you've got people who you're advising or you have people, that would be one of the things that I would recommend you do. Have we got a checklist that we can have? Can we have some photographs? Can we have them, have a consultant come in and visit them if they're going to be working from home permanently? What are the best ways of managing our risk? In the same way that we would if they were working in the office, because it is basically their workplace now as well as their home. Okay, key areas of risk. So work health safety, really good segue to that one. Underpayments, payment and compliance, and conduct and performance concerns. I think I've touched on most of those in the context of talking about our documents and the way that we can use systems and processes to manage some of these risks. Couple of suggestions here just before I finish up about how to deal with that stuff. What are our suggestions in terms of managing some of those areas of risk? The first one I think sounds really self-evident, but when I talk to people in businesses, we do a lot of investigation work here at ABLA as well. And so when we talk to people who have made complaints or in the course of conducting those investigations, one of the major themes that comes up time and time again is communication. So I didn't know what was going on. I didn't understand what the expectations of my role were. I didn't know that they'd changed my reporting line and I was supposed to be doing something else. I didn't know that I was supposed to check in to have my overtime confirmed or verified before I actually worked it. We need to actually talk to people about what's going on. That's really important. The second one there is being clear and specific. So this is particularly important if you're talking to clients about, difficult employees, people they might be thinking about performance managing. One of the major pitfalls I see people fall into when they're thinking about undertaking these processes is by being very general in their concerns and how they express them and shying away from some of those difficult conversations. Just as they would come to you and ask for specific advice about certain things, the discussion they have with their employees needs to be specific as well. And then finally, just really empower your clients to know when they don't know something, it's okay to come and ask the question. If they come and ask you and you don't know the answer, you can both find someone to get that information from together. That's a much better outcome than people assuming or continuing on as they always have and potentially ending up in unintentionally in a world of pain, whether that's with respect to underpayments or some other type of compliance issue. So a little plug here for us. The third point on that slide is one of my most recommended. If you would like to sign up, we have free monthly webcasts separately from the awesome stuff that your association's doing as well. Some of them obviously might be relevant, some of them less relevant, but they're free and they're great around this time of the day as well, so you can watch them while you're doing other things. We also do training courses as well if anyone's interested in that. We have guides and stuff as well. So lots of stuff that we can help with, in addition to, of course, providing advice and assistance. But that's my details. If anyone would like to get in touch by email or phone, feel free. And I'm going to shut up now and give Phil all of about 4 minutes to talk about all of the things that he needed to talk about.
That's perfect. Thanks, Kate. Thanks so much. So what I actually wanted to share and finish off with today is basically everything that Kate has talked about today wraps up around policies, documents, contracts of employment, storage, and most importantly, secure storage. Right, we had our cyber session last time, and we were talking about how important it is to protect people's information, especially your clients' data, but also their employee data in their records too. So one of the things that the workplace product does in conjunction with ABLA, of course, because they prepare all our documents, they prepare all our policies, and of course they provide the advice. So one of the things with our products that you can always recommend to your clients is that when you call, part of the product offering is an advice line, and I'll show you really quickly what that actually looks like. That you pick up the phone, they're not sure what's going on, or they need to make someone redundant, or there's a problem, a contract problem, or they need to hire someone, and it's been a while since they've hired someone. What contract do they use? Because as we know, it gets difficult. Or what do they pay? Right? I know it's what you guys do a lot of the time, but sometimes it's difficult to know because all the different situations. So part of what the My Business Workplace product does is covers you as a platform, as a tool to help you or your clients get through this quite confusing thing. And we keep it really simple too. So we go against everything, against other HR systems. We're not a HR system, we're a tool to help people get through some of the compliance things around workplace and IR. So what we want to focus on only is recruit, manage, exit people, and modern awards. And again, that's all backed by ABLA in the background and everything we do in our system. So what does that actually mean? We make it really easy using checklists. If your clients need to hire someone and they haven't done it for a while, or it's for a sales job or a manufacturing job, things are very different. They can use different checklists to understand what they need to do. Find the right contracts to use too, depending on the situation. And of course, how to onboard people for the first time, and tools and letters if you need to do a background check, if they actually need to get reference checks done. Again, try to support them as much as possible on things they probably don't do every day, or some of them do this every day, right? So we're trying to support as much as possible. And if they do get stuck, it's so easy to pick up the phone and call the workplace advice line, right? And of course, managing employees, as we said, there's a lot of contracts, there's a lot of policies around. So having the right document library and performance management and grievances and complaint handling, of course, it sort of backs up everything that Kate was saying about this is how you use the documents, this is how you use your policies when you do need to use them, and there's instructions on how to actually do that. And of course, separating from your employees at the time, the client's employees in this case, there's different types of separation. As Kate mentioned, you have to get it right, because just because you're thinking about performance managing someone out and you think, oh, you know what, redundancy is easier, it does get a bit, it's in a gray area. You've got to be really careful what you're doing. So again, following checklists on what to do, and if this is a true redundancy, or is this a termination, performance management, etc. So helping your clients and the employees, etc., get through some of this difficult stuff that we always do. And we made it really simple. So with 3 clicks, you get to the information that you're looking for. And if you're not sure, you pick up the phone and you call us. And last but not least, the modern awards and how to pay, right? We have a whole section that you can subscribe to, exactly what the Fair Work does. What we do, the ABLA team actually wraps it up with an explainer. And that's the confusing thing. The modern awards covers employees and employers, basically trying to explain things on how things should work. We make it really easy for the employer to understand why this has happened and how they need to use it and what situation. And I must admit, I think about 30% of the calls we do get is around modern awards sometimes too, because things are so, you've got an office manager, then you have someone in reception sometimes, and it seems like they do some of the same tasks, but not exactly. People get stuck on these topics quite often. So obviously we're looking at these templates and how to implement the 5 core policies. And when you do get stuck, as I mentioned, you always can call the advice line, and this is what it looks like in the back end, and all the advice support calls end up here. So you see what you've talked about with ABLA in the past. Huge array of documents, 170 documents that people can access basically. And you can see, really importantly, the update dates. They get updated quite often by ABLA. So something changes, they've gone to Fair Work about a case, they come back and say, hey, Phil, we need to do something about this document because how the Fair Work decided on this case, we might need to add something in there to protect our clients. And we're quite often working off the back of that. I know we're out of time, so basically I won't stream through all the policies that Kate has mentioned, but these are all available on the system. And if you do want more information about these policies, of course, you can use the QR code right now, and it will take you to the page with all the information and pricing for your clients. So please save it, pass it on to your client. So not sure if we do have enough time.
Phil, are we signing up, for example, am I signing up myself on behalf of all my clients, or am I giving your information to my clients and asking them to sign up directly?
That is actually a great question. So we do have one of the products, and if you're getting in touch with us, one of our products is for advisors, basically. So you can do this on behalf of your clients, right? But what we also suggest, if people are busy doing what they know, their core business, and I know some of our accounting firms and members basically that do roll around bookkeeping too, have a consultancy firm on the side, like, another part of their business that does a little bit of consulting stuff. So we can actually, the product can be made for advisors that they add their clients, and they can help them with adding employees, record keeping for them, etc. But what we do recommend in a basic state, depending on your clients, that they do have this own record keeping themselves, because you don't want to be, again, responsible for situation and events that happen in the business that you are not made aware of. So it's really good that the clients have this system, and what they can do is actually give you access if you need. So we do have an access for advisors that they can log into the system and make sure their modern awards are the right ones selected. They're getting the right updates for the modern awards. I think the team takes about 8 hours from Fair Work updating an award. 8 hours we've updated with our output of basically what this means, what it means to you, how many people are affected, and we send out emails to everyone who's subscribed to those particular awards, exactly like Fair Work would do, but we have an explainer on there and how this actually works into the future.
Fantastic.
Yeah, so if we have time for questions, I know people are still on. We still have
anyone who needed to rush off is probably gone. If there's any burning questions, do it right now. Otherwise, as usual, the recording will go up on the website, and I'll talk to you guys about slides and whether we can add any slides. We'll do that later. Thanks everybody for coming. It was great presentation. You covered a lot of ground. And but yeah, really great to get that from the employment law specialists who are telling us what's important in our world. So thank you both. Really great to have you. And for all the members, the next Tech Talk will be January, nothing doing in December. So thanks again, everybody.
Thank you.
Thanks, everyone.
Appreciate the opportunity.
See you again. Yeah, thanks, Kate. Thanks, Phil.
Goodbye.
Bye.